All right, so just some ideas here. This is by no means a complete list, but these are sort of, 5 top of mind ideas in terms of what you can do in supporting your estate planning documents with evidence. And I'll just, big picture, let's think about this. We're planning now, someone may die 25 years later, right? And I'll tell you that generally speaking, what's created or in existence contemporaneous with that estate plan is going to have much more evidentiary value than something that is created by an expert witness 25 years later following a very stale breadcrumb trail, right? So that's why I really support documenting things if you're in a situation where you're doing anything other than a generic, I have 3 kids, divide by 3, right? That's less likely to be challenged unless you've got a verruca on your hands. And we'll get to that in a second. But some of these ideas are bolstering your estate plan with evidence by recording your intent on camera, right? So this is beyond the testator's intent in the document. Now, recording your intent on camera is extrinsic evidence rather than being in the 4 corners of the document. So, it may or may not be permissible depending on the circumstance. The other thing that I think is, especially with a higher net worth family and a higher potential for litigation, utilizing capacity declarations that are judicial counsel forms for conservatorships. They're check the box forms that doctors can easily fill out. And having that signed and dated, you can put that in your file, or, the best practice would be a geriatric psychiatrist, which is what's most commonly used in litigation related to capacity. And I've cited the probate codes related to capacity 810 to 812. But having a written doctor's opinion after seeing that person is, it's highlighted there or it's in bold, because I think that that's probably the most powerful thing. And the closest you can get to the time of the execution of the document to have that opinion coincide with that date, within the day or maybe just the week, perhaps the month, is just so powerful. And then ensure the planner is a younger practitioner. If, again, let's say you're doing a plan and you're in your 60s, right? If you have a planner that's in their 90s, they're not going to be around to be a witness in mathematic likelihood. So you may want to sort of consider that, right? When you're really trying to make sure that whoever is the drafting attorney is going to be available to call as a witness. I will tell you that I had a case where, there's a major disinheritance going on. There's already pending litigation, and one of the relatives found an estate planner who was about 3 hours away from where they lived. Drove dad out there, like I said, 3 hours from where dad lived, and had dad draft the plan with a planner who was 89 years old. And by the time the trial came, the planner was, he wasn't deceased at that point, but he was in the hospital, with not a good prognosis. And I think that they did it because they did not want the planner to be challenged on cross-examination. So obviously in this case, we're trying to ensure the estate plan prevails. We want to use somebody who is going to be there defending what happens. I don't know why this has evidentiary value, to be frank. I guess it's because of the the respect that members of the bar have and our duty to be forthright. But frankly, I've never met a planner who's going to stand up and say, yeah, I probably committed malpractice, and I had to tell them 13 times that it was Tuesday, and they kept thinking I was at a doctor, and I kept telling them I was their lawyer. Nobody's going to say that, right? They're going to say, oh, they were perfectly fine. But it does have evidentiary value regardless of whether I agree with it or not. All right, gifting assets during your lifetime and executing deeds of gift, if appropriate, that indicate that it's an advance on inheritance, if that's the intention. A completed gift well before death is much more difficult to challenge. And then last but not least, if we've got a situation where we just know we've got a kid who has sued, aunt for grandma's estate, and they've been divorced 5 times, and they have anger management issues, and they sue everybody under the sun. Some people are so fearful of putting their other kids or beneficiaries in harm's way that they essentially want a pre-death determination of the validity of the documents. And there are 6 jurisdictions that do that. So you may want to counsel them to create a trust in those jurisdictions and fund the trust, and then file to have it determined to be valid. I'll say that. And by the way, if you want to know what those jurisdictions are, it's New Hampshire, Nevada, Ohio, South Dakota, Alaska, and whatever, fill in the blanks. I don't know. Email me if you want the 6th, because I can't remember it. But I would say that this is something truly to be considered, because if mom or dad is alive and they filed that petition to have it determined valid, mom or dad is going to be a witness. They're still alive, right? And so by virtue of that alone, when they get that notice, they're not going to challenge it, because they know they're going to be defeated, because mom or dad would just be on the stand. So it's really lessening the likelihood of litigation.